Alright, folks, this is one of three filings that was filed on 5/10/2022. Michael Reesbach's reply brief opposing defendant Netflix Incorporated's motion to compel. Michael Griesbach, by his attorneys, Mayer Graf Wallace, LLP, provides the following in opposition to defendant Netflix Incorporated's motion to compel. Argument: Netflix is not entitled to discovery from Griesbach's under federal rule. Parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case, considering the importance of the issue at stake in the action, the amount in controversy, the party's relative access to relevant information, the party's resources, the importance of discovery and resolving the issues, and whether the burden of expensive proposed discovery outweighs the likely benefit. Netflix fails the test in nearly every respect. Prior to being retained as counsel in the matter, Mr. Griesbach authored two books concerning the events surrounding Stephen Avery saga: The Innocent Killer and a Wrongful Conviction and an Astonishing Aftermath, and Indefensible. The Missing Truth About Stephen Avery, Teresa Halbach, and the Making a Murder. Netflix asserts Mr. Griesbach's books show that he uniquely possesses non-public information relevant to the case. But in fact, other than the three insequential matters Netflix cited after scouring through 540 pages of Mr. Griesbach's books, Griesbach relied exclusively on publicly available information. Mr. Griesbach has repeatedly informed Netflix that the information they seek is already in their possession and is available to them via public access, a much less burdensome alternative than Mr. Griesbach supplying Netflix with a substantial amount of duplicative information. Further, Mr. Griesbach is not the only person to have taken an interest in the Stephen Avery saga. It is not the only person to have published materials in the matter. Numerous other authors have published books on Mr. Avery and the convictions. This is where it becomes clear. Netflix is not merely on a search for information relevant to this matter. Netflix seeks to bog down Mr. Colborn's counsel with burdensome discovery requests after Mr. Griesbach's ability to effectively act as counsel and potentially entangle him in the matter as a witness. With a few expectations, Mr. Griesbach has not relied on anything other than the same materials that Netflix has access to in the making of his documentary series. By its own admission, has not subpoenaed any other authors who published materials. Interestingly, a number of those authors had actual involvement in the Avery saga. For example, Ken Kratz. Mr. Kratz authored the novel Avery, The Case Against Stephen Avery, and What Making a Murder Got Wrong. Mr. Kratz was heavily involved in events portrayed in Making a Murder, as he was the lead prosecutor in the Avery matter. Simply reading the title indicates that the material speaks directly to Netflix Making a Murder. On the other side of the case, with attorney Jerome F. Buting, who later authored Illusion of Justice Inside Making a Murder in America's Broken System. Other authors and their novels and publications about Mr. Avery and their investigations and convictions which he faced included John Ferrick, Wrecking Crew, Demolishing the Case Against Stephen Avery, Scott Carson, Stephen Avery Facts, Nonfiction, Michael Whitmore, Stephen Avery, a Biography, Rebecca Frost, Media and the Murderer, Jack the Ripper, Stephen Avery and the Enduring Formula for Notoriety, Roger Harrington, The Making of a Murderer, The Real Stephen Avery Story, Arnold Stone, Stephen Avery and the Biography, Kelly Ritter, Stephen Avery, The Case Through the Eyes of Supporters, Sam Dennis McDonough, The Innocence and the Guilt of Stephen Avery, Michael D. Cicchini, Convicting Avery, Bizarre Laws of the Broken System Behind the Making of a Murder, Allison Grusing, Stephen Avery, A Case Study, Making a Murder of Making an Identity, Brenda Irish, Hinselman, Haters, an essay on the reaction to the Stephen Avery movie, Sean Atwood, Unmaking a Murderer, The Framing of Stephen Avery and Brendan Dassey, The Humanist Group, Motion Denied, Dismantling Making a Murderer 2, Anthony Costello, Stephen Avery, Missing Evidence, The Examination of the Making a Murder documentary. Again, Netflix has not made requests of any of these other authors, leading us to ask why they would be insistent that they need materials for their defense, yet they do not seek it from very easily incinerable potential sources? The answer is clear. Netflix is attempting to pry into Mr. Colbert. These are all assumptions on their behalf, if I might point out. Mr. Colborn's counsel mind attempting to burden him to duplicate unnecessary discovery requests to place more strain on what already complex and burdensome matter. But the results of Mr. Griesbach's research and opinions are well known to Netflix as they are published. Moreover, it's not Mr. Griesbach's opinions that are being litigated. The issue herein is how Netflix portrayed events and how the portrayal affected Mr. Colborn, Netflix states. Specifically, how both the underlying court proceedings and later, impacted opinions of Mr. Colborn held not to only Mr. Griesbach but also by others in the community, many of whom Mr. Griesbach knew and possibly interviewed for his books, are relevant to Mr. Colborn's reputation and his damages. This assertion seems to imply that somehow Mr. Griesbach's personal opinion of Mr. Colborn is issue in the matter. While Netflix claims it's not seeking anything more than documents, it's clear by the statement that it seeks something more. The fact that Netflix is admitting that they want to obtain Mr. Griesbach's opinion again points to desire to undermine Mr. Griesbach's ability to act as a zealous advocate for his client and possibly entangle him in an attorney-witness matter. Further, the relevance of Mr. Griesbach's opinion in the matter clearly does not have a forceful effect. Netflix insinuates. What need would there be for trial at all if Mr. Griesbach could simply sway the court or public opinion with such ease? Simply, per Mr. Griesbach's research and publishing of this novel, have no bearing on the way Netflix chooses to portray matters, how people were influenced by such portrayal, and what damages Mr. Colborn has suffered. There is nothing from which Netflix can glean any discoverable or relevant information from which it does not already possess or that can easily obtain via public access. As such, the burden of and expense of complying with Netflix subpoena vastly outweighs any benefit, namely because there's no benefit. Compliance with the subpoena serves only to burden Mr. Colborn's counsel. And a second justification for subpoenaing one of Mr. Colborn's attorneys, Netflix exaggerates Mr. Griesbach's involvement in the Avery case. Themselves, Griesbach's involvement was extremely limited, and as pointed out in his initial brief, the subject matter of the involvement is already a matter of the public record. Netflix has failed to demonstrate that Griesbach's negligible involvement in the fourth of his declaration might lead to information relevant to Mr. Colborn's defamation case. As Netflix correctly points out, the court must consider a totality of circumstances, weighing the value of the material sought against the burden of providing it, and taking into account society's interest in furthering the truth-seeking function in the particular case before the court. Despite Mr. Griesbach's repeated efforts to explain to Netflix that all information is available to them, Netflix persists. Interestingly, Netflix admits that it has not issued document subpoenas to any third parties other than the Manitowoc County Sheriff's Department, including those individuals listed in Mr. Griesbach's opposition. That begs the question, what makes Mr. Griesbach stand out to Netflix such as they are requesting all of his burdensome information? Information that already possesses and have access to Mr. Griesbach and their documentary series Making a Murder demonstrate. Netflix has now admitted that they are subpoenaed documents from Manitowoc County Sheriff's Department and individuals who would actually possess information about the investigation. Mr. Griesbach did not waive his reporter privilege. One of Mr. Griesbach's objections to the subpoena is that the efforts fall under Wisconsin reporter privilege. While Netflix indicates that Mr. Griesbach waived such privilege by failing to bring such objection, the neglect to mention of the objection is conveyed during the March 11, 2022 meet and confer reading. Netflix subpoena. Thus, Netflix was aware that Mr. Griesbach was making such objection. However, Netflix argues that even if Mr. Griesbach did not waive the privilege, Mr. Griesbach is not entitled to the privilege to do so, banning when it became counsel for Mr. Colborn. And Mr. Griesbach has repeatedly indicated that nothing which is relied upon has been kept secret from Netflix. Netflix asserts that there's something with Mr. Griesbach had access to which it does not. The case cited by Netflix. Significant to the court is the defendants and comparatively disadvantaged by Hale's involvement in plaintiff's representation for the last 2 years. Plaintiff's counsel, though Hale's mind and memory, has access to certain relevant information the defendant's counsel does not. Based on the motion to compel, defendants appreciate the inquiry have rightfully demonstrated their willingness to forgive the situation. Again, Mr. Griesbach relied on the same information which Netflix utilized to make its documentary. Further, the fact that Netflix already has access to information which is requested and demonstrates the burden of placing on Mr. Griesbach by forcing him to provide requested documents is not sufficient to overcome the reporter privilege. A circuit court may issue a subpoena to compel a news person to testify about a disclosure procedure in any news, information, identity of any source. If the court finds, after the notice, that to an opportunity to hear the news person, if the person requesting the subpoena established based information obtained from a person other than the news person by clear and convicting evidence. In a civil action proceeding, the complaint states the complaint upon which relief can be granted. However, this is only a limitation. A circuit court may issue a subpoena under B only if all the following conditions are met. The news, information, identity of the source is highly relevant to the investigation, prosecution, action, and proceeding. The news, information, identity of the source necessarily the maintenance of the party's claim, defense, or the proof of issue, material of investigation, prosecution, action, and proceeding. The news, information, identity of the source is not obtainable from any other alternative source for the investigation, prosecution, action, or proceeding. There is an overriding public interest in the disclosure of the news, information, or identity of the source. The Wisconsin legislature provided an express means in which the reporter privilege may be overcome, and Netflix has failed to demonstrate that this burden is met. Netflix has not shown that there is information which is highly relevant to the investigation or defense, nor has demonstrated that the documents are necessary to the defense or proof of any issue material of this matter. This is because Netflix cannot make such a showing if Netflix already possesses information. Further, because information is publicly available in Netflix possession, Netflix cannot possibly argue that information is not obtainable from an alternative source. Lastly, Netflix has not demonstrated any overriding public interest in the disclosure of the requested documents. The Wisconsin legislature is clear that Netflix may overcome the privilege. Netflix argument based on Illinois' matter, interpreting that Illinois' reporter privilege does not overcome Wisconsin's own reporter privilege. Lastly, facts of assignment easily differentiated from those herein. Will a cursory review of assignment reveals that Mr. Hale reported turn attorney tried to involve the reporter privilege in more in-depth reviews with Mr. Hale, far more involved in the underlying matter than Mr. Griesbach. Mr. Griesbach did not have anything to do with making a murder or the events on which he premised outside of being attorney of the district attorney's office at the time of the search warrant, a subsequent recusal of the office to Mr. Hale. On the other hand, was extensively involved in the underlying matter, as was the filmmakers, executive producer of the documentary. The plaintiff argued created false evidence against him to frame him for a murder which he was at the center of the case. Mr. Hale's role included reading the case documents, coordinating and conducting witness interviews, determining what footage to shoot, helping develop the story structure of the piece, reviewing raw footage. Mr. Griesbach was no way involved in filming the production and making a murder. He did not affect which way Netflix chose to portray information, unlike Mr. Hale, who dictated which to portray the documentary at issue. As such, the court was validly concerned about the information Mr. Hale possessed, which could give him inequitably advantage over the opposing side. Unlike Mr. Griesbach, Mr. Hale was actively involved in the events portrayed in the documentary in the manner in which were portrayed. Mr. Griesbach had no influence on the events surrounding Mr. Avery, nor did he have any influence on Netflix portrayal of the events of making a murder. Accordingly, the reporter privilege is not waived, nor does this cause appears to the privilege under the case law or the statute. Conclusion. Federal Rule Civil P-26-1B1 requires that the court considers various factors when determining whether a party may obtain discovery. The rule provides that the court should consider whether the material requested is proportional to the needs of the case. The party's resources and need for the requested documents outweighs the burden and the expense of the request. Netflix has failed to demonstrate that the need of the discovery outweighs the burden and expense of it would place on Mr. Griesbach. The burden they speak to place on Mr. Griesbach simply is not justified or productive. Furthermore, Netflix readily admits that it's only sought information from other third-party source, the Manitowoc County Sheriff's Department. Certainly there are numerous other parties that have been involved in events depicted in making a murder, and many others have written other such events. That begs us to ask the question, why Mr. Griesbach? The answer is clear. Netflix is a multi-billion-dollar corporation which already has access to documents which they have requested. Mr. Griesbach is an attorney representing a retired law enforcement officer. The document requests are merely a thinly veiled effort to undermine Mr. Griesbach's efforts to act as counsel by taxing his time, energy, and funds, not to mention potentially embroil him into attorney-witness conflict. Lastly, Mr. Griesbach has not waived reporter privilege. Netflix was made aware of the privilege when the parties discussed the subpoena in March. Further, Wisconsin outlines the specific of circumstances under which the reporter privilege may overcome. Netflix has failed to demonstrate that they are entitled to documents pursuant to Wisconsin Statute 855-14C. Simon simply does not apply to the interrupts the Illinois reporter privilege, does not consider the Wisconsin statutory expectation of the privilege and factually distinguishable from the matter of the hand. For the reasons accused above, Attorney Michael Griesbach respectfully requests that the court deny Netflix motion to compel. There's two other documents filed today. That's the affidavit by Michael Griesbach and the other one. I will be downloading those, and I will bring both of those probably in the same one. So I'll see you guys very shortly.